Welcome back. Another day, another dollar. This is the third in the series of lecture videos for the first part of topic 3, which is the carriage of goods by sea. So I want to focus here on bills of lading. So what is a bill of lading? The definition. Basically an instrument issued by an ocean carrier and given to a shipper with whom the carrier has entered into a contract for the carriage of goods at the time the goods are delivered to the carrier. What does that mean? Unhelpfully, while the term bill of lading is defined in the Hamburg rules, it is not in fact defined as clearly or as such in the Hague-Visby rules, which are the Australian version. So when we're talking about bills of lading, we're really got to go beyond sort of the broad definition and think about actually what it does and what it's for. So we're talking about a document here. It's a multi-purpose document that has 3 primary roles: a receipt for the goods shipped, evidence of the carriage of the contract of carriage, and it's also a document of title. So it's really important for all of the seller, the carrier, and the buyer. So basically, how does it work? When goods arrive at a dock for shipment, they're inspected by somebody, usually a tally clerk, whose job it is to ensure that the cargo matches what has been agreed upon. The tally clerk, or sometimes the mate, as they're referred to, remember, the captain and Gilligan, his mate. The mate's record can be critical because it details the quantity and the conditions of goods, and this ultimately is put onto the bill of lading and becomes part of the record. Traditionally, the shipper is the one who puts the bill of lading together, and the carrier provides a standard form. So one of the videos that is in the lecture series here is basically a basics on bills of lading, which is published by a carrier company, basically explaining how their form works. So the purpose of it, once it's completed, is so that the carrier will confirm that they've received the goods and then takes on the obligation to deliver them in accordance with the terms. In practice, it's not just one document, but a set of 3 original bills of lading that are drawn up. So why do we have 3 of them? Basically for safety and for verification. They're in triplicate. They're compared with the tally clerk's notes for accuracy, and then they'll be signed by the carrier. The 3 originals are then handed back to the shipper, who will use them to prove that they've fulfilled their part of the contract or to transfer rights to the goods while they're in transit. Of course, for that to happen, there needs to be a clean bill of lading. So what are we talking about here? Basically, that's an assurance. A clean bill will be issued when the bill of lading doesn't have any remarks or clauses that indicate a deficiency or some kind of discrepancy in the cargo. A clean bill of lading is a carrier's thumbs up, sort of an indication that the goods have been loaded on board in apparent good order and condition. So clearly a bill of lading, while it is just a sheet of paper, it's not just a sheet of paper. It's a pivotal document that can dictate the success of a transaction. And so one of the things I find particularly interesting is that they really are still mostly bits of paper in this age of electronics. And given the critical nature of this form of doing business, it seems to me for a very long time something that is rife for innovation and improvement. A slide here gives a couple of examples of bills of lading. As you can see, they're forms, but I'm not going to go through this in any detail here. We will probably talk about it in the tutorial. Basically, it's worth looking at the Bill of Lading Basics video to get a sense of how the form comes together. And Article 15 of the Hamburg Rules will also set out what's required if the Hamburg Rules applied, which might also be useful to you. So coming back to it, I mentioned right at the beginning that there are three purposes here: the receipt of goods, evidence of contract, and document of title. So basically, it's important to make sure that we understand that when the carrier receives the cargo, whether it's through an agent or otherwise, and in fact that is often the tally clerk at the dock, they inspect and make an official count or measurement. The outcome of the inspection is documented, and this is referred to as I mentioned before, the mate's receipt. The initial receipt confirms the carrier has received the goods in specific condition and quantity. The mate's receipt is then used to issue the bill of lading, which serves as a more formal acknowledgement. So clearly, we end up with a claused bill of lading when there is a discrepancy between what the shipper has put on the bill and what the tally clerk actually identifies as being the cargo. It's also evidence of a contract. So the contract of carriage is generally concluded once the shipper and carrier agree on the transportation terms, but the bill of lading will serve as written evidence that that agreement has been reached. It outlines the terms, whether that's by reference or on the document itself, and it identifies when the goods will be transported, what route will be taken, the delivery point, and the obligations that the carrier has. So this aspect of the bill of lading is particularly important in transactions where no formal freight contract has been drawn up, because all the essential terms are contained in the one document. And perhaps the most significant role that the bill of lading has is its function as a document of title. So the document represents ownership or title to the goods described in it, which means the person who holds possession of a bill of lading typically is the one who can claim possession of the goods themselves. So essentially they're onboarded onto the vessel. Once the bill of lading is issued, it is then sent on to the person at the other end who's going to collect those goods. And because it is a document of title, that person could in fact actually sell those goods while they're in transit, and somebody completely different might be showing up to collect the goods with that bill of lading. So 3 original copies, I've already talked to you about that. Worth having a look in your textbook in the 7th edition. Finally have it in my hands. We're talking paragraphs, or chapter 3, paragraphs 45 to 47 will probably give you the key issues there, and there are a number of cases that work through or demonstrate the importance of the bill of lading there. So what's the governing law for bills of lading? So here I really want to explore the legal framework. Clearly you already know a bill of lading is a critical document in international trade. It evidences the contract of carriage, it serves as a receipt, and it can also document title. But how is it actually regulated? So let's start with the international approach. So the foundation rules would be the International Convention for the Unification of Certain Rules on Law Relating to Bills of Lading, way back in 1924. You guessed it, I'm talking about the Hague Rules. We've talked about these before and the way that they were amended, and as a consequence, we've now got the Hague-Visby Rules, which form the basis of the Australian position. In domestic legislation, and Australia is not the only one, we're seeing basically legislation across a range of different states, often called Carriage of Goods by Sea Acts, or COGSs. So the Australian Carriage of Goods by Sea Act incorporates the Hague-Visby rules into its domestic law, and that forms part of the schedule. Many nation states also have supplementary legislation governing bills of lading in both municipal and international settings. Supplementary legislation often covers areas not detailed in international conventions or adapts the general rules to fit the specific and commercial environment of a jurisdiction. I only point this out really to demonstrate just how unification has really not been achieved and harmonisation we're even further away from. So if you want to push this out further, make sure that you've read what the textbook says from chapter 3, paragraph 48 onwards. It's interesting actually that Hague-Visby doesn't have a definition of bills of lading as such, but Hamburg does. But anyway, let's move on and have a quick chat about the content of the Hague-Visby rules. We're going to look at that in the context of the Australian Carriage of Goods by Sea Act, the Commonwealth Act. So the Act incorporates the amended version of the Hague rules, so the Hague-Visby rules, and as a consequence, they've become part of Australian domestic federal law. So in particular, this Act regulates the carriage of goods by sea in ships carrying goods to or from Australian ports in foreign trade. It prescribes the rights and responsibilities of carriers and shippers under a contract of carriage, which includes a bill of lading. So Article 10 of the original Hague rules set out when they would apply, but this is been modified by Hague-Visby. And basically, one of the key modifications is that broadening and simplified applicability. So essentially, we're capturing here all sea carriage documents. So there's an automatic application. The Hague-Visby rules apply automatically to bills of lading issued in a country that is a party to those rules. Any bill of lading if the carriage is from a port in Australia, irrespective of where the bill of lading is issued, and contracts of carriage where the stipulated port of loading or discharge is Australia. There's a mandatory application. The legislation mandates that the Hague-Visby rules will apply to all eligible carriage of goods by sea, and the rules cannot be contracted out of to the detriment of the shipper. This means that any clause in a contract of carriage that lessens the carrier's responsibilities or increases the shipper's responsibilities beyond what Hague-Visby rules say would typically be void. Thirdly, limitation of liabilities. The Hague-Visby rules set out limitations on the carrier's liabilities and establish a range of immunities from and limitations to liability for loss or damage to the cargo. The Act enforces these limitations within the Australian context, and the ambition here is a uniform approach to the carrier's liabilities as established by the International Convention. It also has an extended application. It might have an extended application to cover certain contracts that include a sea carriage component, even if the bill of lading doesn't strictly conform to the traditional format, provided the essential elements of a carriage by sea are present. And that's something that I spoke about in the previous video. And as I said just a minute ago, and the slide says, the Act applies to sea carriage documents, broadly defined to include not only bills of lading, but also waybills, ship delivery orders, and the like. So it's widened the scope of documents to which the Hague-Visby rules can apply in Australia. And so the Act ensures that the Hague-Visby rules are applied in Australia to the relevant contracts of carriage by sea. The way it's been implemented is aimed at providing certainty and uniformity in the legal treatment of these contracts, which is critical for international trade. So you can see how easily a choice of law issue could come up. So if the rules do apply, all the rules apply. They're incorporated into the contract of carriage and you can't exclude them. That's Article 3.8. And it covers the period from the time when the goods are loaded on to the time they're discharged from the ship. So, as I mentioned a number of times, bill of lading, it's more than just a piece of paper. It's the lifeblood of the shipping industry, and it's the documents that facilitate global trade every day. Article 3.3 of the Hague-Visby rules captures the essence of a bill of lading. I guess it's an acknowledgement by the carrier that they've received and loaded the goods onto the vessel. It's a really important part of the process of the shipping journey. It marks the transition of responsibility for the goods from the shipper to the carrier. And it's the carrier's duty, and usually a non-negotiable obligation, to issue the bill of lading. The document serves as an undeniable testament to the receipt of the goods. So let's consider what a bill of lading actually describes. Think about it as a kind of identity card for the cargo, maybe. It's always going to include that description of the goods. It's going to detail what they are, how many there are, and what kind of condition they're in. And it needs to do that with incredible precision. If it's meant to be specific enough to hold weight in the event of a dispute. Bills that confirm the goods have been properly loaded on the ship are often referred to as on-board bills of lading. So this designation essentially is that a carrier has declared that they've successfully loaded the cargo. Now, when we've looked at where the risks are, clearly there's a risk in getting something from the dock onto the ship. And so an on-board bill of lading will be particularly important when that relevant Incoterm is something like FOB, free on board, where there is a change in the party's responsibility for the goods at the point where it lands on the ship. So when we have disputes, the carrier's statement in the bill of lading are considered prima facie evidence. In other words, they're accepted as true unless proven otherwise. So if they say that the goods were indeed received as described, then that's all that the party needs to deliver. Of course, it's not infallible, so let's think about what rights the carrier might have to rebut that evidence. Until the bill of lading is negotiated or transferred to a third party, the carrier retains the right to present evidence to challenge the presumption. And this clause is crucial because it provides a mechanism for the carrier to correct inaccuracies or defend against claims regarding the condition or quality of the goods. So the starting point is essentially a rebuttable presumption that the goods are as stated on the bill of lading. Now think about, why is that presumption only rebuttable if the bill of lading hasn't actually been negotiated or transferred to somebody else? And that's because the bill of lading is also a document of title. And so if somebody has sold the goods in transit, then the buyer is entitled to believe or to accept that the goods are in the condition and of the quantity described on the bill at the time that they buy it. So you can see, I keep coming back to this, don't I? It's a significant part of the process. And the point of it is for it to be a robust record, a witness to the transaction between the shipper and the carrier. So think about the scenarios where the accuracy of a bill of lading could be contested, and think about what that might mean for the parties involved. And if you have questions or experiences or comments, let's have a chat about that in the tutorial. So I mentioned before this idea of a claused bill of lading. This type of bill of lading bears a significant importance. It arises when there are discrepancies or reservation about the cargo that the tally clerk or the mate observe. When a carrier notes the discrepancy or some sort of reservation directly on the bill of lading, so perhaps they note that there's been some kind of damage to the goods or shortfall in quantity, then the document is referred to as a claused bill of lading. The notations that they make provide transparency about the condition of the goods at the time of loading, and clearly they're a key issue for everybody involved. Clearly, a clause bill of lading is normally less desirable to third parties, for example, banks or who are lending money on the goods, or purchasers of goods in transit, because they indicate that the goods were not received in the condition or the quality that were as expected, and that in turn can affect their value or suitability for the intended purpose. It's important to note that any notation regarding a discrepancy needs to be made at the precise time the goods are loaded. The timing's critical. It's the point at time when the carrier verifies the condition of the goods and asserts their observations. So if notations are made after that time, they generally have no effect, and the bill of lading will be treated as if it were clean, implying that the goods were loaded according to the contract's terms in apparent good order and condition. And why does this matter? Because the integrity of trade relies on the trust that the documents are accurate, that they reflect the good status at the time they're made, and alterations or late notations undermine that trust and can lead to disputes and claims, particularly as those alterations or notations would be made by the party who has control over the goods at the time that those notations are made, the carrier. So think about it. What would you advise a client who received a claused bill of lading? What kind of things do you think they might be able to do to protect their interests? Have a think about that. So, as I've said before, a bill of lading is not necessarily a contract of carriage, but it's usually the best evidence of the contract. The terms and conditions are usually on the reverse side or on another document that is identifiable from the face of the bill itself. The contract is made up of many documents. It could be the advertisements, the booking note, the freight tariff, online terms and conditions, and sometimes even certain practices that the carrier has that are known and accepted by the shipper, all taken together. And then the key terms, the variable terms, are noted on the document itself. One of the most important aspects of a bill of lading is that it is a document of title. It's not just a piece of paper, as I keep on saying. So if you hold a bill of lading, that grants the person who is the rightful possessor of the bill title to the goods, which empowers them to possess, use, and ultimately dispose of the goods that the bills represent. It's like holding a key, I guess. The person who holds the key to the treasure chest, or in this case, the bill of lading, has control over the treasure in the chest or on the ship. So this is why it's really important to think then about what responsibilities the carrier has. It's really important for the carrier to ensure that the delivery of goods at destination is strictly made against the surrender of the bill of lading by the consignee. Why? Because if the carrier delivers it to somebody without actually getting hold of the bill, they're taking a big risk. It's akin to handing over the keys to that treasure chest to somebody without actually making sure that they are, in fact, the owner. If the carrier were to deliver the goods to the wrong person, someone who doesn't hold or can't present the bill of lading, then the carrier could be liable for breach of contract, or worse, accused of wrongfully converting the goods, taking or using somebody else's property without permission. And this is something that clearly carriers take huge risks to avoid. But as I mentioned before, we're talking paper documents here. So they can get lost, they can get damaged, they can get wet. All sorts of things can go wrong in the process. So I find it really interesting that such a linchpin part of the safeguarding of rights over goods being transported is done in this really analog manual form. So think about another thing that might be worth thinking about is the systems that carriers have in place to mitigate the risks of misdelivery and how these processes might evolve with the advent of digital bills of lading or the use of the blockchain, for example. I'd like to talk about that as well, if we can, in the tutorial perhaps. Okay, before I finish up this video and the next one, which I hope will be the last one, I'm going to focus on the carrier's duties. Just want to identify two main kinds of bills of lading. The straight bill of lading, so that's a bill that's issued to a named consignee and isn't negotiable. So the transfer of a straight bill gives the transferee no greater rights than those of the transferor. An order bill of lading, that's a bill that is issued to a named consignee and is negotiable. So the consignee may transfer the bill to a third party by negotiation. So they endorse and deliver, similar to how we used to endorse a check or something like that in the olden days. And the third party holder of the bill then has title and the right to take possession of the goods described in the bill, provided that they've received the bill in good faith through due negotiation and that they surrender the bill to the carrier in order to take delivery of the goods. So there are more different types, and the textbook goes through those at some length. And again, this might be something that interests you, and happy to talk about it in more detail in the tutorial. I'm just cognizant of time. And so in the last video in this series, we're talking a little bit more about carrier's duties. And unless you have questions, concerns, frustrations, or compliments, I will see you then.